Now, exclusive possession, there is no clear definition. So the court said that whether a person has an exclusive possession of a piece of land or a flat, or it is a matter of facts. This is something that the court will look at the reality in order to decide whether the occupier has exclusive possession. And now, why it is necessary to distinguish a license and a lease if both are involving paying a rent for occupying certain premises for a fixed period of time. Now, it was because in the old days, in Hong Kong, it was not that old. Before Sir Donald became the Hong Kong chief executive, we have in Hong Kong law to protect the right of tenant. There are two forms of protection. One is called security of tenure. The other is called rent control. Now remember, rent is the fees that the tenant pay to the landlord, and security of tenure refers to the term of that lease. Tenure refers to the duration of holding. Security of tenure means that, in theory, you can, or a tenant can, occupy that land forever. When this coupled with rent control, landlord cannot increase the rent freely. What will you do if you are a landlord? You would avoid renting out your premises to a tenant. You want to have temporary arrangements such as a license. You can always kick the licensee out. And therefore, people would try to avoid creating a tenancy or a lease with another person so that they can have more control of the property they have. In fact, in England, it was even, the rules are even more in favor of the tenants. Now in Hong Kong, we divided lands in Hong Kong into, well, there is a so-called landlords and tenants consolidation ordinance. That divided land in Hong Kong into different parts. For the part 1 or part 2, they're referring to some really old land. For those parts, we still have security of tenure. As long as the tenant is willing to pay market rent of the premises, then they could stay in the premises as long as they like. Now, rent control has already been get rid of early, I think in the 1980s. So rent control is not that important. In fact, if the landlord want to increase the rent drastically, the tenant can take the landlord to the land tribunal for the land tribunal to decide what would be the fair market rent. As long as the tenant is willing to pay that fair market rent, then they can stay. in the old days, the rent, because the government wants the society to be stable, so they want to keep people at their home. If everyone was being turned out by landlord, and they have to, occupy the street, there would be social unrest. They would have protests, etc. Therefore, they impose security of tenure and rent control on these lists. The problem is that would be at the expense of the landlord. So, the law is changing from time to time. For example, Hong Kong rent control gone and security tenure also gone in 2005, after SARS. And before, if you want to terminate a tenancy agreement with your tenant, you have to serve them certain forms. You have to serve them a form called CR101, just like the tunnel bus. And the tenant, if they want to stay, they will serve the landlord, CR102. And then they will end up have a litigation in land tribunal to decide whether the tenant is willing to pay a market rent and stay on. But Sir Donald's government get rid of this security of tenure. Therefore, nowadays, the landlord can always terminate or always refuse to renew any tenancy with the tenant. Now, when you have lifelong security of tenure under control rent, the landlord, of course, would not like to grant a list, but only license to an occupier, because the licensee would not get any protection whatsoever in relation to security of tenure or rent control. Now, going back to just all these cases, it was decided in the 80s, 5th month of 1985. This Arnold's case, 1988, and potential assurance case, 1992. Well, that was the time when this law of rent control and security of tenure was still effective in England. Nowadays, they have a new concept called short hold tenancy. By the way, if you want to purchase a property in London or England for investment, don't be afraid, because short hold tenancy would allow the landlord to grant a lease to a tenant, but this lease cannot last more than 335 days. 1 day less than 1 year. Usually, that would be the term for such a short hold tenancy, and the landlord can get the land back if he or she does not want to renew the contract. And rent control is not also applicable for short hold tenancy. But in Hong Kong, of course, we do not have the short hold tenancy either. But because of that, we do not have rent control or security of tenure. Now, of course, the government is talking about rent control for Tong Fong, but that would not be really that threatening for landlords in Hong Kong, because the Tong Fong would only be a small percentage of housing available in Hong Kong. So in Hong Kong, it is no longer important whether you're granting a lease or or a license to an occupier, because as long as the contract, the term of that license or tenancy expire, the landlord can always get back the land. And therefore, as I said earlier, in practice, it's no longer important to distinguish a lease from a license. But still, for the purposes of land law, this is important. Examiner usually like to ask questions on that. Now, as we said many times now, all land in Hong Kong except the land on which St. John Cathedral stands, which is a freehold land, all land are leasehold. Well, by the way, there is a condition for freehold in St. John Cathedral. It must be used for religious purpose. So if the British Church wants to lock down the church and build a high rise, then it would be in breach of that grants, and government can get the land back. Now, since all land are leasehold, the government in the past will grant a document called Crown List before 1997. Now they are known as government lists to the lessee. When you go to auction to bid a piece of land, remember you are not an owner, you are only a lessee, and the government grants you a list to show that you are now the tenant for that piece of land. And in the past, there's a real physical document of Crown List given to you if you actually get the land in auction. And in the old days, because that was the practice in England, we have the document in the form of an indenture. Now, what is an indenture? Okay, a big piece of paper. It is divided into two parts. Both parts are mirror image to each other. And each part will be signed by one party to this transaction. Say, for example, a landlord and a lessor and a lessee, the government, will sign on this part, and the lessee sign on this part. Then the government will keep this part, and the lessee will keep this part. And in the middle, it is not just a straight line, but something like so that when the two pieces are put together, it forms one single document. Oh, this is the real document. It is not easy for someone to forge a part which has the same kind of shape as the original indenture. That was the document in the old days. Now, when CPO was enacted, the government tried to take advantage of this ordinance to forget about altogether this government list. And Section 14 said that a government list is deemed to be issued once the conditions of sale has been performed. Now, when you go to auction to get a piece of land, there are a lot of conditions imposed on the winner of that auction, the winning bidder. They have to develop that piece of land within a certain period of time, and they have many obligations to fulfill in order to develop the land. For example, in certain development, the developer has to build a bus terminal or a taxi stand, a flyover to connect this piece of land to another piece of land. They have to do all this thing in accordance with the conditions of sale. Now, once the conditions are satisfied, then under Section 14 CPO, the government list is deemed to be issued. Now, once the government list is issued, the person will obtain the legal estate of that piece of land. And of course, by virtue of his payment on sale, he also acquire the equitable interest. Now, this condition would also not just impose duty on that developer to do something for the government, they would also lay down the use of that piece of land. Domestic use, commercial use, domestic commercial, or the special term is domestic commercial, industrial, for example. And then of course you have to use that piece of land in accordance with the permitted use. Now, if all these covenants, all these conditions are being satisfied, you would then invite the director of lands to inspect your development. And the director of lands will, have in front of him, of course not him, but his staff, all the conditions, and they will sign, this has been done, this has been done. And then they will issue you a certificate for compliance, CC, certificate of compliance. That means you have complied with all the conditions. Now, this certificate of compliance has nothing to do with the title of that land. But nowadays, it becomes the most important document to show that a government list has been issued under Section 14. Because Section 14 said that a government list is deemed to be issued when all the conditions are being satisfied. So this certificate of compliance now becomes the evidence of compliance, and therefore the issue of the government list. So serve as the documentary proof. And it also means, government list deemed to have been issued. So once you get this certificate of compliance, your legal estate is conferred on you by the government. Okay, if certificate of compliance is so important, what would happen if no certificate of compliance is obtained by the developer? You would say, well, land is so important in Hong Kong, no developer would forget to get this certificate of compliance. But we do have such developer. Now the case Chen and Lord Energy. Any one of you are living in Blackhill Villa in Victoria Road? Big one. Now, that was the case is about a sale and purchase of a unit in Blackhill Villa. And in that transaction, the purchaser, after he obtained all the title documents from the vendor's solicitor, well, when you go to conveyancing, will go into detail about that. He looked at the documents one by one. Of course, the first thing he want to see is this certificate of compliance, because Villa was developed after the CPO was enacted. So there should not be any physical document of Crown list. They could not find one. So he raised a requisition is technical term. It means he asked the vendor solicitor, what happened? Can you produce me the certificate of compliance to prove that you have the legal estate of that flat? And then it was discovered no certificate of compliance has ever been issued to the developer of this housing estate. And for so many years, you know, Villa was completed in 1970 something, 99, 20 years old. No one cared about the certificate of compliance. You can see Hong Kong people are so crazy about, you know, real property. As long as there is real property available, they would just purchase it without really caring about what kind of title they're going to get. And in that case, in fact, one of the document missing for the lands department to issue the certificate of compliance is the car park layout plan. You know, they have to show the director of lands, you know, in fact, when whatever domestic development, you have to get permission from the government how many car park spaces you are allowed to provide. You know, in fact, you know, for new buildings in Hong Kong, new development in Hong Kong, the number of car park spaces are, you know, less than the number of units. But in Villa, each unit would have at least one car park. But anyway, that is one of the reasons, you know, the director of lands did not issue the certificate of compliance, because there is no evidence that the car park has been, the installation of the car park has been complied with the condition of sale. And of course, the vendor said, well, nothing is nothing. You know, there's so many people living in Backyard Village. They are not worried. Why are you worried? We will not suffer no loss. But of course, the other party will say, no. It would be dangerous, because if without this government list, that means you do not have the legal estate. You are only selling me the equitable interest. But in the sale and purchase agreement, you expressly said that you will convey to me both legal estate and equitable interest. So it is a breach of contract. And the 1999 is also an important year. As you still remember, 1997, housing price in Hong Kong went rocket high, and then in November, when the financial storm came, price dropped drastically. Of course, another reason for this purchaser who wants to back off is because he rather enter into a new contract and get a much cheaper flat in the same housing estate. And in that case, it went all the way to the Court of Final Appeal. The Court of Final Appeal actually said, under Section 14 CPO, it does not say that the certificate of compliance is required to show government list is deemed to have been issued. The condition is factual compliance. If you are complied with all the conditions, that would be enough. this certificate of compliance is only a documentary evidence that all the condition has been complete. So if the lawyer representing the vendor was clever enough, he should have said, don't worry, we have done everything. Even the car park layout plan has not been given to the Director of Lands. We have the car park layout plan here, and it is in compliance with the condition. Then he would have satisfactorily answered the requisition, and the vendor the purchaser has to complete. But they did not say that. They cannot answer the requisition raised by the purchaser. So as a result, they are in breach of the contract. They cannot show they are selling a good title. And of course, don't worry, after this case, all the owner in Backyard Villa try to have some remedial action. They immediately apply for the certificate of compliance, and it is now available. So if you purchase any flat there, in relation to this problem, there should not be any worry. And under the government list, we have to learn one more thing. When the government grants you a list, the government is actually acting as the landlord. Of course, the land belonged to the state or PLC, or before 1997, the British Crown. The government is only the agent. But anyway, the government is acting in the capacity of the landlord. Now, if the government is acting in the capacity of the landlord, the government is just like any individual landlord. They can do whatever thing to its advantage. And the concept of public law, judicial review, does not apply. Now, for example, if you want to build or construct a building, you must submit building plans, architectural design to the buildings department. And one thing about the building is about the design of the building, disposition, whether the building should face north or face east, etc. Height, how high the building would be, has to be approved by two departments. One is the buildings or department. They are looking at from the construction, from the architectural perspective. Also from the Director of Lands. Now, Director of Lands is not acting as if he's a government official. He's acting as an agent for the government as landlord. And he'll give you approval for this design, disposition, and height. And then the buildings ordinance, the buildings department will then look at those design, disposition, and decide, that is architecturally possible. So they also give you permission, and you can start building your start the building works. Now, so far, the Director of Land has not required any developer to pay a fees for his approval of this so-called DD&H clause, that is, in fact, to approve the design, disposition, and height of the development. Now, if one day, so for example, after the policy speech, our chief executive said, well, having second thought, because now we want to have more land and we want to have new laws against the developers in Hong Kong. The Director of Lands will lodge a fees, will require fees to be paid by the developer for the approval. Now, if it is a government act, then the developer, if they are being affected by the decision of the government, they can go to court to get judicial review. But in this particular example, when the Director of Lands giving approval to the clause, the Director of Lands acting as the agent of the government as landlord, then this is private matters, and the judicial review would not be applicable. So the whole purpose here, we'll come back to this, the other requirement about building ordinance. The whole purpose here is to demonstrate to you the complexity of land law in another level. The government is both the regulator controlling the building regulations through the buildings department. At the same time, the government is also the private landlord. So whenever you are dealing with lands in Hong Kong with the government, you have to be very clear about what particular role the government is playing. If they are playing as a regulator, any decision made by the government which has adverse effect on you, you can go to court and apply for judicial review against that decision. But if the government is acting as the private landlord, then no matter how unfair, unreasonable the decision he made against you as landowner or lessee, you have no remedy whatsoever. Now, in fact, a few years ago, I represent a group of landowners in the new territories when they try to build some small house on the hill of certain area. I don't want to mention the area in Sha Tin. Because the land itself is on the hill, they need a road, for vehicles to go from the ground to the hill. And they ask the government to allow them to have such a vehicular access. But the government say no. And my client instruct me, of course, there was a case which I was led by senior counsel, instruct me to have a judicial review against the decision of the government. And the court, in fact, we went all the way to the Court of Appeal. Court of Appeal affirmed the view of the court first instance. Well, when the government refusing us, they are acting as a private landlord, but not as the regulator. Therefore, we have no recourse, we do not have any remedy for that situation. Now, okay, coming back to the second department, the Director of Lands, acting as the land agent of the landlord. We have also the buildings department that look at the architectural and constructive aspect of this design, disposition, and height. Now, you must get the approval of the building authority before you start any of the construction work. I have to stress the word must, because under Section 14 of the Buildings Ordinance, if you commence with any building work without the prior approval of the Director of Lands and I'm sorry, I think it should be the it's not really the Director of Land, but for it should be the Director. No, it's the Building Authority. I'm sorry, there was a typo here. The approval of the Building Authority. Then your structure, no matter how much you have already finished, must be illegal structure and has to be demolished. And Section 14, it has been concluded by law, by court, that no retrospective approval is possible. You must get the approval before you can do anything. Now, if, say for example, you jump the gun, before you get the approval, you already built some structure. That particular structure must be illegal structure. And any illegal structure present in a land will render the title to the land a bad title. Well, we'll come back to this concept when we discuss conveyancing. But at this stage, just remember that whenever there are illegal structure present in a property, the title of that property is inevitably a bad title. Okay, so that is something I already talked about. If the Director of Land as the land agent of the government, then his decision would not be subject to any judicial review. And you cannot base upon the public law concept of legitimate expectation to tie the government law to charge you any premium or any fees for approving your DDH clause. Now, of course, the government can grant or sell the land to the lessee. If the government is not really selling the land, they can just grant you for free a piece of land. Exchange, that means you have a piece of land to begin with, and you use your piece of land to exchange for another piece of land. We grant is, government already grants you a piece of land, but under the lease, for example, that piece of land is restricted for agricultural use. And the government can cancel that lease and re-grant you another lease in respect of the same piece of land. Maybe allow you to construct a domestic building on that agricultural land. So we just re-grant you. Or extension, that means to extend the term of that lease. Now, no matter the government exchange the land with you, grant you or re-grant you or extending the lease, the government can set out some conditions for the grantee to observe and fulfill. Just like when the government sells the land, they can require the developer to satisfy certain conditions. And this is also an exam question. Examiner would ask you, what kind of conditions would you expect to see in a government list? Or ask you to name 5 clauses in a government list. The standard condition of a government list would include a term of the grant with or without a right to renew. In fact, 75 years, and attached to that 75 years, there was a right to renew the lease. And of course, in the government list, there's also a term in relation to rent. Usually we call that ground rent. And the government may require you to impose on you a duty to repair the piece of land, including repair the slope next to the piece of land. User of the land, how the land is to be used, agricultural, domestic, commercial, industrial, etc. And in that list, the government also will list out the lessee's obligation to comply with ordinance and regulations, and the rights to re-enter of the government in case of serious breach. Now, what does it mean by re-enter? That is to say, the government can enter your, now you have exclusive possession, so during that term, the government cannot enter your land. But if you are in breach of those conditions in the government list, the government can terminate your list and re-enter. That means he now enter into the land, and your list would be terminated. And this is something we already mentioned before 1997. Terms of Crown list may vary from 999 years to 75 years. And by virtue of the joint declaration, all leases granted before will expire on this day. Now, in theory, if you really have a list of 999 years, the government may still recognize it, but it really up to the government, because in any event, the current system of Hong Kong under the concept of one country, two system, in theory will expire on the 30th of June 2047. So in fact, in a study in 2016, people would, of course not just common people, but the surveyors and lawyers has conducted a research to find how the surveyors evaluate land with 999 years list to a list which will expire, at least on paper, on the 30th of June 2047. And it is found that there is a difference of about, if I remember correctly, 5.25%. So Tai Kusing would enjoy 5.25% more than if it is going to expire on the 30th of June 2047. So this reflects, people actually do not trust the 999 years would be recognized. Otherwise, it would not be such a small difference. And soon after Hong Kong became Hong Kong SAR, on the 16th of June, 15 days later, 1997, the Hong Kong Executive Council announced that new leases after the 1st of July 1997 would be granted for a term of 50 years from the date of the grant. Okay? So any new land being sold after the 1st of July 1997 can extend beyond 30th of June 2047. And subject to payment of premium. Premium is the sum of money they have to pay during after the auction, and the so-called rent, ground rent, would be 3% of the rateable value of the land. And some, before 1997, Crown leases come with a right of renewal. And under that press release, it is said that the lease may be renewed without a further payment of premium. And in fact, I don't know whether I have mentioned this to your class or not. Before 1997, if a lease expires, the lessee would have to pay a huge amount of money as premium for renewing or extending that lease. But in that past release, it is said that the lease might be because the government can say no, but so far government has never said no. So might be renewed without further payment, and if the lease itself does not provide a right of renewal, then the lessee has to apply for renewal. And again, nowadays, after 1997, the government would said that the list will be automatically extended to 30th of June 2047 without any premium, but the ground rent would be 3% of the rateable value. So with or without rights for renewal, the same thing. But it is expressly said that the government may, as its sole discretion, to do that. So in theory, government can say no, I'm not going to grant you the extension. Now, so how can the government leases be terminated? Now, of course, a lease is a term of year absolute. There will be a definite ending for that lease. So if the terms expire, in theory, the lease will be terminated unless it is renewed by the government following the press release on the 16th of July, 1997. Now, the second possibility to terminate a lease is the tenant, the lessee, surrender the lease back to the government. It's like, you rent your place for 3 years from your landlord, but 2 years has passed and you want to move to a new places, you can surrender. You can give it back, give the land back to your landlord. Similarly, any lessee can surrender the lease to the government. If the government accepts the surrender, then the lease is terminated. Now, if the government does not accept surrender, then even though the lessee left the land, the government will then occupy the land. The government still, as private landlord, sue for the rents of the residual years of the lease. So it is a huge difference if the government accept or not accept the surrender. The same apply to our private tenancy. Say the example I gave, 3-year tenancy. After 2 years, you want to surrender the lease to your landlord. If your landlord accept your surrender, okay, you can just leave the premises without any problem. But if your landlord does not accept your surrender, you will be considered to have breached the condition of the lease, and then the landlord can sue you for the rent of the remaining 1 year. But of course, given the great value of land in Hong Kong, surrender is rather unlikely to happen. Except we are talking about exchanging will surrender the list of of one piece of land in exchange for another piece of land. Now, re-entry, we already briefly mentioned about this concept, means the landlord can physically repossess the land during the tenure of a lease. And this usually happens when the lessee is in breach of some important conditions of the grant or covenants in the lease, such as covenant to pay rents timely, grant rent. Even though we're talking about a few $100 in most cases for a flat, if you fail to pay the ground rent, government can re-enter your premises. And in fact, in all government lists, there is always this clause contains the right of re-entry by the government. And we have a particular ordinance called the Government Rights Re-entry and Vesting Remedies Ordinance. Under Section 3, it allows the government to exercise this right of re-entry. Even, there is the good thing about being a government. If you're a private landlord, you actually have to repossess physically the piece of land. But for the government, re-entry can be effected without any actual re-entry. What is required for the government is to register a memorial of an instrument of re-entry at the land registry. So government can just prepare the document saying that now I'm exercising my rights under this particular clause in the government list to re-enter, and then register that document in a memorial in the land registry. Then the legal effect is that government has already re-entered upon the land described in the original in the government list. Now, the original list determines. I just want to introduce to you this particular term. If you look at private tenancy agreement, if you need to sign one, you come across this term, determines. Now, the common usage of that is to decide or to think about something, to make up your mind. But when it's used in the context of a lease, determine means terminates. Now, under that ordinance, Section 5, the government is also required to publish that registered memorial in the Gazette. So, in fact, they have to do two things. Section 4, they have to register the memorial, and then under Section 5, they have to publish the memorial in the Gazette. Now, once these two steps were being taken, the land would be re-entered. That means the original lessee will have to vacate the land, and he will not get any refund of the premium already paid or get any compensation, no matter how many years remained for that particular lease. Now, that applies to a physical piece of land. What about undivided share in a multi-story building? Now, the re-entry in that case would be different. The re-entry is effected not by registering a memorial, but by a vesting notice. It is actually just a document to be registered, but just the description is different. It is called a vesting notice registered in the land registry under Section 6. Once this vesting notice is registered, the interest of the land, that means the equal and divided share held by that co-owner, will be vested not in the government directly. The government has set up a corporation called the Financial Secretary Incorporated. It is just like a company. this particular financial secretary incorporated will then becomes the owner of those equal undivided share. And again, the notice has to be gazetted as well as serve on the owner. That means they have to send a copy to the owner, informing him that your under equal undivided share has now vested in the financial secretary incorporated. Please vacate that particular flat. Now, it is a drastic step when the government re-enter a piece of land or some equal undivided shares in a multi-story building. Therefore, the ordinance itself gives a chance for the former owner to get back the land or the equal undivided share. And they can either make a petition to the chief executive, directly write to Mrs. Lam, or apply to the court of first instance within 6 months of the registration of the memorial or vesting notice. So within that 6 months, you must act immediately and make a petition to the chief executive and ask him or her to, give you back the land, to vacate the re-entry memorial or vesting notice. Now, under this section, you can only choose one. You can either choose to make a petition to the chief executive or apply to the court of first instance. You cannot have both. Now, what are the difference between the two routes? Now, the good thing about making a petition to a chief executive is that the chief executive, because he is the real landlord, he has the power to extend the 6-month requirement. So even if you make the petition 7th month or later, after the re-entry memorial or vesting notice was gazetted and registered, you can still make a petition to the chief executive. Of course, in that case, you have to explain why there was a delay. And the chief executive will have unfettered, unrestricted discretion to allow or reject the petition. And if they allowed your petition, that is to say, they will re-grant you the land, and they can, remember, when the government re-grants, they can impose conditions on you. And because, again, as I said earlier, government wears two hats. When he's acting as the private landlord, he can do whatever thing he likes, no matter how unreasonable. So in fact, in this Li Shuyuan case, the court held that the governor, of course, that was before 1997, the governor might impose any condition, and it was not necessary for the condition to be reasonable, because it's a private landlord. Now, CFI, the court of first instance, would have no power to extend the 6 months. So if you are already 6 months, the 6 months have already expired, you could only have one option, making a petition to the chief executive. But if you are acting on time within the 6 months, you can make the application to the CFI. And CFI, will then treat it that it is a matter between a private private landlord and a private tenant, just like any other disputes of private lease. Again, the re-entry under private landlord and tenant, we will use another term to describe that. This is a forfeiture of lease, just like re-entry has the same meaning. And if they find that, there is reason for the lessee to be in breach of a condition, for example, if that's the case, the court may make an order to cancel the memorial or vesting notice. Once the memorial and vesting notice are being cancelled, the lease continue as if no re-entry has been taken place. And in this Chen Hong case, Justice Liu held that there were no rigid rules for guiding the exercise of judicial discretion in such an application, and the court would take into account all the circumstances, including the conduct of the parties. So it's just like any other disputes between landlord and tenant in other circumstances. You may look at the case law to see or to find any reason to persuade the court to cancel the vesting order or memorial. Now, the fourth way to terminate a lease is by resumption. Now you should remember, resumption is a lawful declaration of private property, recognized by Article 105 of the Basic Law. In fact, a government can always terminate a lease by resumption, but there is one requirement for government to exercise that right. The resumption must be for public purpose. And nowadays, if the government has to resume any land, they have to do it under Lands Resumption Ordinance. But in fact, there are other ordinances which give the power to the government to resume any land for specific use. For example, if the government wants your land for building roads, then they can take advantage of Roads Work Use and Compensation Ordinance. Or if the MTR needs your land for building the MTR facility, then they can use the Mass Transit Railway Land Resumption and Easement Ordinance. Now, by the way, I don't know whether you were aware of this or not. When the Hong Kong Island line was extended to Kennedy Town, the government did have resumed certain land, under quotation mark, of people, particularly living in the Sai Ying Pun and until Kennedy Town. But I think none of you would notice any difference because the resumption is actually the underground. They have to build the underground tunnel across those lands. Remember, the ownership includes your right all the way to hell, right? So when the tunnel has to go through your building, they have to ask for your permission. Of course, the government this is for public use, right? So they just resume that particular portion of soil under your building. And of course, if it is resumption, normally the government will have to pay you compensation. Now, of course, in the example I just gave earlier, the resumption of the underground would not cause any loss at all to the lessee. So in those cases, of course, the government would only be required to pay some nominal compensation. But if your entire piece of land is being resumed, then the government has to pay you the value of the land at the date of the resumption. And there's quite a complicated law in relation to resumption, how to value the land. But of course, the good news about it is that we are not required to know details of the resumption law. Say, for example, the government is only required to pay you the existing market value of the piece of land, even though they are going to tear down the old building and rebuild a modernized skyscrapers, which will give much, much, much higher value than the existing value. You cannot enjoy the fruit of that development. You can only be entitled to the existing value of the land. Of course, the government is talking about resumption in the new territories, the North New Territories, for provide more housing. But other than that, one of the most important reasons for resumption in Hong Kong is for urban renewal. And we have the so-called Urban Renewal Authority to deal with that. They have resumed the old towns in Hong Kong. The old like the Mong Kok, Wan Chai, the Western District of Hong Kong Island. Now, before the Urban Renewal Authority was actually established in 2001. Before 2001, there was a corporation. Again, of course, this is a public body, the Land Development Corporation, the LDC. This is the LDC's duty to deal with resumption of old Hong Kong for redevelopment. There was an ordinance called Land Development Corporation Ordinance, which governed how the Land Development Corporation can resume. Of course, it is actually a government resume, but at least make a recommendation to the chief executive for resumption. And when I came to practice, I have luckily, I was lucky enough to handle a great number of cases done under the Land Development Corporation. But unfortunately, when I learned all the law, the Urban Renewal Authority was established. So even though the practice did bring good income to me, but now all those law becomes a waste. And why the government want to replace Land Development or Corporation by URA? It was because under that ordinance, the LDC was required to acquire the land privately through negotiation with the owners. And it was only after the LDC has taken all reasonable steps to acquire the land, including negotiating for the purchase of the land on a fair and reasonable terms, to require the LDC to do it fairly and reasonably, but still fail to acquire the land, then they can apply to the Secretary for Planning to recommend to Chief Executive for resumption. Now, because they have to do this, therefore, we lawyers can have some grants to earn some money. But now the LDC was set up to replace, the URA is set up to replace LDC, and such requirement was no longer applicable for the Urban Renewal Authority. Now the URA is empowered to go directly to the Secretary for Planning and then to request certain land to be resumed after an offer for sale is made to the landlord and not accepted. Now, of course, it does not mean the URA can do whatever they like, because the existing requirement is that before the URA can ask the government to resume certain part of the land, they must have at least acquired 80% of the interest in the property. So in a way, they still have to negotiate with the private owners for the purchase of their land before resumption. But at least there is no requirement that they have to do it fairly and reasonably. So it solved a lot of problem for the government to resume any old lands for development. So if you are not satisfied with the price offered by the URA, you can argue under the Lands Resumption Ordinance before the tribunal for more compensation. But in most cases, that is not an easy task. Okay, we're going to a new topic. Maybe this just 2 minutes before 45. Maybe it's a good time for us to stop. So I will see you next Monday.